Bring that,
15th district, is that down in?
that's downtown Ann Arbor.
Oh, okay,
Okay.
yeah.
All right. You have any other questions about the plea or the charge? Andy, you have my copy of War and Peace. I could probably finish it up. Okay.
Ready?
You are?
Yeah.
Oh, I'm sorry.
We're waiting on you.
Oh, really?
Okay, we're ready. Really, this time.
For real?
Really.
Okay, go ahead. I'm not moving until for sure.
Yeah.
Go ahead.
There has been a plea agreement worked out. I believe the court should have a copy of that.
I do not. What? Are we still waiting on Miss Reiser?
Yeah, I've signed the plea agreement. We're all set. She's just making copies to bring in so that everybody has.
We can make copies here. Where is she? Judge Washington is really pressuring me to get off my, and
There she is.
Sorry, Judge. Amy Reiser on behalf of the people.
I didn't have anything bad to say about you, but you should have heard these people. I defend you.
I can only imagine. You got a time and date set for the preliminary exam in this matter. I've had an opportunity to speak with counsel, and we have reached a misdemeanor plea agreement. The people are moving to add account 5 of assault and battery. The PAC code for that is 750.81. That's a misdemeanor, punish up to 93 days in jail and or a $500 fine. And also add account 6 and 7 of attempted resisting and obstructing. And the PAC code for each of the added count 6 and 7 is 750.81D1A. That's a misdemeanor, punished up to 1 year in jail and or $1,000 fine. Upon the court's acceptance of a no contest plea, and I believe that's based on intoxication, to count 4, the disorderly obscene, the added count 5, 6, and 7, the people would then move to dismiss count 1, CSE 4th degree, count 2, felony resisting and obstructing, and count 3, felony resisting and obstructing. The people and the defense agree in terms of sentencing, there will be no delayed or deferred. The probationary term, if he's sentenced to probation, is 2 years. He will receive alcohol treatment, and there will be a no-go to the city of Ann Arbor, and a no contact will continue with Isabella Kraft or any other minors.
That is what the plea form indicates to me. And all I would do is indicate that this court cannot bind the sentencing judge in this matter, but I understand what the agreement of the parties is.
Thank you, Your Honor. That is also our understanding. My client is ready to be sworn.
Has he signed an advice arrest form? Of course not.
Thank you. Sign. Questions?
Right. I said,
Yes. I know.
what's the date, sir?
Let Judge Washington know I'm doing what I can. However, some people aren't being very cooperative. May I have him sworn?
Raise your right hand. You solemnly swear and affirm the testimony you're about to give with the truth, the whole truth, and nothing but the truth, so help you God.
Yeah.
State your name.
Franklin Joseph Melton.
Mr. Melton, it's this court's understanding you're going to plead no contest to 4 charges. Is that your understanding?
No contest,
To 4 charges.
4 charges.
Yes, sir.
I thought it was 3.
There are 3 charges that have been added, and that my understanding is you're also going to plead no contest to the stated count 4.
What are the 3 charges that have been added, sir?
All right. Here's what the court's understanding you're going to plead no contest to. Count 5, which is the added charge of assault and battery. That's a misdemeanor punishable by up to 93 days of $500 fine plus court costs. You understand that?
Yeah.
Okay. Count 6 is attempted resisting and obstructing. That's also a misdemeanor punishable by up to 1 year incarceration or a $1,000 fine plus court costs. You understand that?
Yeah.
All right. Count 7 is attempted resisting and obstructing, the same charge. That's punishable by up to 1 year and or a $1,000 fine plus court costs. Do you understand that?
Yeah.
Okay, so those are the 3 added charges. It's also this court's understanding you're going to plead no contest to the charge of disorderly person obscene conduct. That's a misdemeanor punishable by up to 90 days and a $500 fine plus court costs. You understand that?
Yeah.
Okay. So you understand the 4 charges?
Yes, sir.
All right. You understand what a no contest plea is?
It means, yes, I do understand that.
Okay. 2 things I need to make sure that you understand. The first thing is that it means that as to those 4 charges that you no longer wish to dispute those charges or fight those charges. You understand that?
Yes, sir.
All right. The second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yeah, yeah. I
You
do
understand that?
Right.
Okay. You also need to understand that while I'm taking your plea, I would not be the judge that would sentence you, and you'd be sentenced before Judge Perry in the 15th District Court.
Yes, sir.
You understand that?
Yeah, yeah.
Okay. Now, understanding all
Do
of
I have
that,
to get down there?
pardon?
I have to get down there?
To the 15th District Court?
Yeah.
I think we'll probably provide transportation for you. But yeah,
Yes,
you need to be there. Okay?
sir.
All right. So any other questions regarding that?
15th district, is that down in?
That's downtown Ann Arbor.
Oh, okay,
Okay?
yeah.
All right. You have any other questions about the plea or the charge?
No, sir.
All right. So to the charge of assault and battery, how do you plead?
No contest?
To the charge of attempted resisting and obstructing, how do you plead?
No contest?
To the charge of attempted resisting and obstructing contained in count 7, how do you plead?
No contest?
And to the charge of disorderly person, obscene conduct, how do you plead?
No contest?
Now, you understand that by pleading no contest, you'll not have a trial of any kind.
Yes, sir.
All right, you signed an advice of right to him today, is that correct?
Yeah, yeah.
Any questions regarding any of those rights?
No, sir.
All right, look at paragraph 5. You'll see a copy on the podium. Those are your rights. Those are your rights, which are part of a trial. You understand that by pleading no contest, you'll be giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead no contest to these charges?
No, sir.
Has anybody threatened you or coerced you?
No, sir.
You're doing this voluntarily
Yes, sir. and
of your own free will.
Yes, sir.
Court has been provided Ann Arbor Police Department report for their case number 23-30258. Any objection to the court reviewing that report?
No, Your Honor, the basis for the no contest plea is lack of memory due to inebriation at the time.
Thank you.
And thank you, Your Honor. We would ask that be marked and admitted as exhibit 1 and the basis for the plea.
Okay, yes. Right, right. I got a list. I'm sorry, sir.
Based upon a review of that report, the court does find that there was a sufficient factual basis in which the court could determine the defendant's guilt of these offenses. Counsel, have I complied with the court rule?
The defense is satisfied, Your Honor.
The people are satisfied.
Court will accept the defendant's pleas of no contest to counts 4, 5, 6, and 7. Counts 1, 2, and 3 are dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this matter will be July 19, 2024 time, 10 a.m. before Judge Perry.
Thank you, Your Honor. My client would ask that I just address bond briefly. He has a lot of arrangements that he needs to get up housing. He needs to get his Social Security benefits back in place. He's asking to be allowed to be out today so that he can start that process. Part of the plea agreement is that he not stay in the city of Ann Arbor. He needs to arrange that housing.
Is not stay in the city of Ann Arbor?
So no go to city of Ann Arbor.
So where is he staying?
He needs to arrange that. He can arrange something Ypsilanti, but he needs to get that in place.
But he doesn't have an address at this point.
Not at this point.
Motion for bond reduction denied. I don't need a response. Bond will continue. Court calls case People versus Devin Miller.
Good morning, Your Honor. Ashley Lonnie for the people.
And my name is Craig. I appear on behalf of Mr. Devin Miller.
All right, what are we doing today? Your name, sir?
Devin Miller.
Thank you.
Your Honor, there are some preliminary matters that are still ongoing under discussion. The parties are requesting an adjournment to July the 18th if possible. I asked for that date because that is when the co-defendant has also set for this case.
And we're in agreement, Your Honor.
Probable cause conference will be adjourned July 18th, 2024, 9 a.m. Bond continued.
Thank
Thank you,
you.
Your Honor.
Thank you. Court calls the cases of People versus Mark Austin.
John Brown, Deputy Chief Public Defender, appearing on behalf of Mr. Austin, I believe. The forensics.
They are not, they're in the forensic center, my understanding. They have not signed in.
So the
forensics
note
center.
here I see is for 11.
Pardon?
The note I see on the docket is for 11 a.m. They may be waiting till that time.
Oh, is it set at 11? Again, your fault, Mr. Brown.
No, it's not. Nothing is Miss Whiting's fault.
I know that is absolutely your fault. You should have known that and should have been able to inform the court of that. I'm appalled at your lack of preparation. Pardon? Oh, he had to have somebody else read it. He doesn't read it. Anyway, I think that's it. We can clear the way and let Judge Washington take over. All right, preliminary examinations before Judge Washington will start momentarily. Those of you that have non-in custody PCCs, we will be down in courtroom A shortly. Court is standing recess. Just started writing stuff.
Good morning, Your Honor. Joy Gaines, Senior Assistant Public Defender, representing Mr. Williams. Your Honor, we referred this matter to our investigator department, and they are ongoing looking into some issues for us. We would ask for a 3-week adjournment so that we can continue to try to.
How long?
3 weeks.
2 weeks. All right. Mr. Williams, can you state your name, please?
Andre Williams.
Thank you. I'll adjourn the matter without objection, July 25th, 2024, 9 a.m. Bound continued.
Thank you, Your Honor.
Thank
Your
you.
Honor,
Yes,
Your
sir.
Honor, is it possible they can do a different time? Because I have classes.
You have classes at 9 o'clock?
It's at 10:30.
Your class is at 10:30?
Yes, sir.
All right, I've set this for 9, so if they get you in, I'll have my staff make a note. So on the 25th, we'll try to get you in and out as quickly as we can.
Okay, thank you.
Thank you. Court does call the case, People versus Thomas Belcher.
Assistant Public Defender with and on behalf of Mr. Belcher.
All right, I guess the first thing is that there were added counts 4 and 5. I don't know if council's been made aware of that.
We were made aware of it. I did tell my client, we have not yet received the complaint.
Okay, we can get a copy of the amended. I think to you, yes, we can get a copy to you. How does your client wish to plead to those charges?
Your Honor, he wishes to stand mute and have the court enter a not guilty.
As to counts 4 and 5,
Yes.
defendants is standing mute. Court will enter a not guilty plea on his behalf. All right, as to the PCC on this,
It has a prelim with the judge.
it has a prelim. Oh, okay. Who is it?
Judge Burke.
On the 9th?
At this
Okay.
time, it's scheduled for July 9th. We are
Yes.
for some additional discovery.
Pardon?
We are awaiting some additional discovery that was discussed with Ms. Tana previously, and I shared that with Ms. Reiser today.
Do you think that's going to be clarified by the 9th or?
We are sincerely hoping so. I know my client wants the case to move forward.
Right, okay, well, I'll just continue it to in person to the preliminary examination on July 9, 2024, 9 a.m. before Judge Burke.
Thank you, Your Honor.
Thank you, Honor. I'll keep in touch with Ms. Gaines if,
Okay, good, thank you.
and Ms. Gaines, I'm emailing you the amended.
Court calls the case People versus Teresa Johnson.
Hi, good morning, Your Honor.
Hello, state your name.
Teresa Johnson.
Thank you.
Mr. John Brown, Deputy Chief Public Defender, appearing on behalf of Ms. Johnson.
All right. What are we doing?
Your Honor, today is the date and time set for a competency review. We do not have an updated report. Court have enough.
I do not have a report. What I will, if we don't have a report, I will adjourn the competency hearing.
I apologize. I was making a note in the other file.
We don't have a report. The people don't have a report either.
No, we don't.
All right, I will adjourn this out then to August 1st, 2024, 9 a.m. If we get a report before then certainly we'll move the date up. Bond will continue.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
Thank you, ma'am. Court does call the case, People versus Daquan Ellis.
Morning, Your Honor. Nicole Hughes, something.
Good morning, Your Honor. Assistant Public Defender Ben Denowith with and on behalf of Mr. Ellis, who stands to my right.
Your name, sir?
Daquan Ellis.
Thank you. What are we doing?
Mr. Ellis is going to demand his exam.
Is discovery complete?
Yes, Your Honor.
People have their witnesses available. People have their witnesses available the 16th. Preliminary examination in person, July 16th, 2024, 9 a.m. That is before Judge Fresh Hour.
Your Honor, my client would like to address bond.
Briefly.
Well, he does have 8 children. He's working full-time, running his own cleaning business. He would like to get back out there and support his children. He has plenty of other family in the area. And I'd say I don't believe he's a danger to the community, at least that rises to the $100,000 cash bond level.
Yeah.
Okay, so he'd ask for a reduction.
Response.
Your Honor, at the time that I charged this case, I requested 100,000 cash surety. $100,000 cash surety. The defendant has a felony history back as far as 1994. From 1994 to 2016, he has numerous theft crimes, firearms crimes, and drug crimes. In 2016, his most recent felony convicted of felonious assault as well as felon in possession of a weapon. To say that he's not a danger to the community is a statement that I don't agree with at all. In this case, the defendant became irate with the domestic violence victim. He began accusing her of cheating on him. He grabbed her by the throat with both hands. She reported that the pressure was tight around her neck, that her perception of it was that it lasted for approximately 4 minutes, that she was gasping for air the entire time. Once he released her neck, he grabbed her wrists, held them behind her, so she was unable to move at all. So the 100,000 is absolutely appropriate. Thank you, Your Honor.
Anything else?
No, Your Honor.
Motion for bond reduction denied. Bond will continue. Court calls case People versus Charles. Is it Peltier Turner?
Good morning, Your Honor. Amy Riser, appearing on behalf of the people.
Good morning, Your Honor. Michael Benson on behalf of Peltier Turner, who is coming forward. Your Honor, today's date and time is set for a PCC. We are missing some discovery and we would like an adjournment. That is be the body cam of Deputy Stumpmeyer.
Of what deputy?
Stumpmeyer. Works in the jail.
July 25th. Will that work?
That works. Thank you.
Probable cause conference, July 25th, 2024, 9 a.m. Bond continue.
Thank you.
I'll check for it. I don't know if he's gonna have body cam.
Court does call the case People versus Sharonda Griffin.
Owen Brown, Deputy Chief Public Defender, living on behalf of Ms. Griffin. For the record.
I'm Sharonda Griffin.
Thank you.
Your Honor, today is the date and time set for the probable cause conference. We believe that this is something we can work out through a universal plea agreement. However, we will need time to work out the details. There's something she has 14 B that has a next court date of July 22nd. So
On 14B matter.
yes. And so once that matter is resolved, we believe that we can resolve this very.
So why don't I put this to the 25th then?
So yes,
Will that make sense? The 25th?
absolutely.
Probable cause conference in these matters will be adjourned July 25th, 2024, 9 a.m. Bond continue.
Your Honor, just briefly on bond, very briefly.
Yes. Go ahead.
She does need to be able to take care. She's the caretaker for her brother. He has a traumatic brain injury. I'm sorry, fiance. And she is the one who basically is his caretaker. He's missing his appointments now. She'd like to be allowed to have a bond so that she continue to help take care of her caretaker.
Well, I think I'd like to give her a bond too, but when I look at the offenses, I have no way of monitoring her or her conditions because I've got tampering with the electronic monitoring devices when we let her out. So I don't need a response from the people. Motion for bond reduction or any changes denied. Thank you. Calls the case People versus Zachary Burlett.
We're ready in that.
Nicole Hughes on behalf of the people.
Warren Brown,
Just disappeared.
Deputy Chief Public Defender, appearing on behalf of Mr. Burlett. Mr. Billette he's at the home of New Vision. He was on the screen. I can
He
only,
was. I saw him. Mr. Burlett.
I'm betting a restroom break, Your Honor.
Oh, he's coming in. Mr. Burlett, there he is. I think you were right.
Good morning. I apologize.
All right.
Mr. Billette, could you state your name for the record, please?
Zachary Thomas Burlett.
Thank you.
Your Honor, today is the date and time set for probable cause conference. I do believe that we are able to work out this matter through a misdemeanor resolution of retail fraud. Second, however, the prosecution will need some time to be able to write that up. So we'd ask for an adjournment, a brief, as brief as can be given, so that we can go over the plea agreement with our client and have the prosecution.
Well, we didn't have to rid him, so I'll do July 11th, 2024.
Thank you, Your Honor.
Bond continue.
Thank you.
Thank you all. Have a happy holiday.
You do the same, sir. Court does call the case People versus David Merriquin.
David Merriquin.
Thank you. All right, what are we doing?
Your Honor, Mr. Merriquin is currently scheduled for competency. I did confirm that hearing or that exam is going to be held on the 26th of July. So we'll be needing
Is when his exam with them,
that is correct. Your Honor. Yes. Evaluation, I guess that's the better.
on the 26th.
July 26th.
Okay. Tell you what I'll do then. Let me put this out. Do I have the 22nd bonus?
Yes.
All right. I'll adjourn his comp hearing then to August 22nd, 2024 at 9. If we get the report earlier, we'll move the date up pursuant to the statute. That way. Okay.
And we would like to address bond, Your Honor.
Go ahead.
Your Honor, Mr. Merriquin is asking that the court consider a release, hopefully on a GPS tether or in the alternative to a treatment facility. He is a mental health recipient. I've reached out to the mental health court who he had completed a particular probationary period with. They can't do anything right now while competency is waiting, but he'd like to see if he could get into some type of substance abuse. I know that one of the bond violations does stem from an allegation of substances found on his person during a routine stop. So he'd like to see if the court would consider at least letting him be released into a treatment facility to start getting treatment.
I normally would not have any objection to that. However, we're pending the report. So at this point, I'm going to deny the request for the bond modification. Thank you.
Thank you, Your Honor.
Calls case People versus Jeffrey Gibbs.
Ready in that matter, Your Honor. Brown, Deputy Chief Public Defender, appearing on behalf of Mr. Jeffrey Gibbs.
Mr. Gibbs? Have they checked in?
Your Honor, I have paged the courtroom. I've received no response. I understand that he had been released from the Washtenaw County Jail. And I do not know if he had information for the new date. So I will respectfully request an adjournment.
Oh, he got it at 8. I gave him the new date. I gave him the date before.
That makes you forget things, Judge.
I forget things? Oh, that'd be you. Bench warrant will issue bond, but we said 10,000 cash surety. That warrant will issue immediately. Thank you.
Thank you.
Court calls the case of the People versus Rebecca McCree. Hello.
Hi. Good morning, Your Honor. Joy Gaines, Senior Assistant Public Defender, representing Ms. Rowe. Would you state your name for the record, please?
Rebecca K. McCree.
Oh, I'm so sorry. Your Honor, at this time, we are requesting an adjournment. We have some additional discovery requests that we'd like to make of the prosecutor.
July 25th, 2024, 9 a.m.
Thank you.
Bond.
Thank you.
Thank you, man. Court calls case People versus Brian Haney.
Andrew Schultz is appearing on behalf.
Court calls case People versus Franklin Melton.
Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Melton. Mr. Melton, state your name for the record.
Franklin Joseph Melton.
Thank you. Come on, people.
Yeah, John Clemens on behalf of people standing in for Amy Reiser, who's next door. I'm taking a waiver real quick.
Okay, so what do we do?
Well, we need to verify a plea offer that we believe has been made. So we need her to be able to come in and say, yes, that is it.
I'm sorry, Your Honor. I'm just trying to stand in and help out here, but I don't have.
Yeah, fine job you're doing.
I know.
I'll pass it. I don't know.
All right.
Court does call the case People versus Marquise Trace.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Trice. Mr. Trice, will you please state your name for the record?
Marquise
hands
Trice.
everybody. Sorry. Thank you. Your Honor, we're asking for an adjournment. I believe there may be some additional discovery that we're waiting on.
July 25th, 2024, 9 a.m. Without objection, bond continued.
Thank you, Your Honor.
Thank you. Court calls the case of the People versus Sterling Paris.
On behalf of the people.
It's got two cases.
Edward Drukas on behalf of Sterling Paris and 4-2 matter.
The public defender in this other matter.
If it was Mr. Denoway.
I did speak with him and we were looking for 2 exam dates.
In your case, Mr. Drukas, all your discovery is complete.
Yes, Your Honor.
People would have their witnesses available on that case, the one ending in 0042. Would you have your witnesses available on the 9th?
That's fine, Your Honor.
Preliminary examination in that matter in person, July 9th, 2024, 9 a.m. That is before Judge. For me. I'm sorry, they should be the 16th. I apologize about the date. Should be July 16th, 9 a.m. before Judge Valvo. That was my mistake. I apologize. Bond on that matter will continue. Mr. Simpson, you're welcome. On the other matter, what are we doing?
Yes, Your Honor. Mr. Paris's matter ending in 1150, Assistant Public Defender Ben Denowith on behalf of Mr. Paris were also demanding exam.
All discovery is complete.
I'm sorry?
Is all discovery complete?
Yes, Your Honor.
People would have their witnesses available the 16th.
Yes, Your Honor.
Preliminary examination in person, July 16th, 2024, 9 a.m. That is before Judge Bravo. Bond continued. Thank you, sir.
Thank you.
Court calls the cases of the People versus Mark Austin.
That's the
That's the
he's
one that
saying.
he wanted me to call.
Not that he wanted you to call, but he indicated he was out of custody.
He's out of custody.
And I was giving you the last out of custody.
That must be him standing up ready to come up. Court calls the case People versus Maurice Anthony.
We are ready in this matter.
Andrew Schultz appearing on behalf of the people.
Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Anthony.
Your name?
For the record.
Maurice Anthony. Thank you.
So, Your Honor, today is the date and time set for preliminary, probable cause conference. Your Honor, Mr. Anthony had been in the Livingston County lockup. He just recently got out. We haven't had a chance to really talk about what's going on in this case. He is here today, so we're asking for an adjournment just to be able to have a conference with our client.
Hearing no objection, July 25th, 2024, 9 a.m. Bond continued.
Thank you very much, July.
Court calls the case of the People versus Corey Peters. That's my last out.
Morning, Mayor. Please, Honorable Court, Rick Johnson from behalf of Peters, who stands to my immediate right.
Your name, sir? Corey Peters. Thank you. What are we doing?
And I'd like these matters to be set for preliminary examination.
All discovery is complete.
Yes, Your Honor.
We'll have their witnesses available the 16th. Preliminary examination in person, July 16th, 2024, 9 a.m. before Judge. Fresh hour.
Your Honor, may I please address my client's bond?
Briefly.
My client is charged with 2 low severity felonies. He does reside in the Washtenaw County area. Do not believe he is a flight risk or danger. Allegations are that there were dumpster fires that he was responsible for. No one was hurt. No real estate was damaged. I asked the court to consider and release him on a PR bond. He has been declared indigent, cannot afford to post monetary bail.
Response.
Thank you. The defendant's bond is denied in circuit court. His next hearing is not until July 17th, after our next date on this file. Also, he was on, I'm sorry, I don't know whether it was bond or probation. I believe it was probation at the time that he set these dumpsters on fire. And so he's now in violation of his circuit court bond as well.
So he's been denied bond in circuit court.
And he's held until after this preliminary examination.
Court calls case People versus Milton Ray.
Morning, may it please the Honorable Court, Kareem Johnson, appearing on behalf of Mr. Ray. It's coming to my immediate right.
Your name, sir?
Ray, John Ray.
Thank you. What are we doing?
And we ask that this matter be set for preliminary examination as well, and I'd like to address Mr. Ray's bond.
All discovery is complete.
Yes, Your Honor.
People would have their witnesses available on the 16th. Preliminary examination in person, July 16th, 2024, 9 a.m. That is before Judge Valvo. As to bond.
Yeah, I do not believe my client is a flight risk or a danger to the community. He has likewise been charged with a low severity felony. I am not aware, I was just appointed yesterday, I'm not aware of any prior felony conviction of my client. Based on the nature of these accusations, I believe my client is entitled to a personal bond. Magistrate who set the bond started with the presumption that my client was entitled to a personal bond as the court rule mandates. I don't see any factors that would have convinced the magistrate to require my client to post a monetary bail, Your Honor, as he be released on personal bond.
Respond.
The defendant has 13 open cases, most of which were open and pending at the time that he committed this offense.
শাড়ি শাড়ি কেন?
আমি কি তোরে কিছু দিতে পারি না?
এমনি করে টাকা খরচ করলে টাকা জমাইবা কেমনে?
দূর, একটা শাড়ির আর কতই দাম।
শাড়িটা কিন্তু সুন্দর আছে।
আচ্ছা একটু পরে দেখা না।
আরেকদিন পরবো।
কি কস? পর না, তোরা অনেকদিন শাড়িতে দেখি না। রাবেয়া, রাবেয়া,
খুলতেছি।
ঘুমাইছো?
অনেকক্ষণ আগেই ঘুমাইছে।
বাজার।
মা, এত বাজার কেন আনছো?
না, এত বাজার কই? ঘরে একটা নতুন মানুষ আসতেছে না, ওর জন্য খাওয়ান দরকার আছে না?
রাক্ষসের মতো খাইবো তো সবাই, এত বাজার করে লইছো।
আরে না, রাক্ষসের কিছু নাই। যাও বাজারটা রাখো। আমি চিন্তা করছি কি, ধার কর্জ করে হইলেও টাকা পয়সা জমায়া একটা সেকেন্ড হ্যান্ড মোটরসাইকেল কিনবো।
মোটরসাইকেল কেন?
আরে ভাড়ায় গাড়ি চালায় খুব একটা লাভ হয় না, এদিকে তেলের দাম বাড়তি, তারপরে যে চাকরিটা করি সেখানে তো টাকা পয়সা খুব বেশি দেয় না। ঘরে একটা নতুন মানুষ এসেছে, আমি যদি এই চাকরিটা ছাইরা যদি বাইক রাইড সারাদিন করি তখন কিছু টাকা আসবো, ভালো হইব না?
দেখো যত যাই কও, চাকরির কিন্তু একটা নিশ্চিত ইনকাম আছে, সেটা কমই হোক। চাকরিটা ছাড়িয়ে দেয় কি ঠিক হইব?
তাও ঠিক, কিন্তু এই যে ঘরে একটা নতুন মানুষ এসেছে, একটু নতুন করে চিন্তা করতে হবে না, টাকা পয়সা লাগবে তো।
জানি না, সেটা করো ভাইবে চিন্তা কইরা,
আচ্ছা তুমি অত চিন্তা করো না, এটা তো এখনই কিনতেছি না, টাকা জমাতেও তো একটা সময় লাগবে, তাও ধরো 6-7 মাস তো লাগবেই। তারপরে রফিকরে কইছি যে যখন মোটরসাইকেল কিনবো তখন কিছু টাকা ধার দিতে, ও রাজি হয়েছে, মিলাজুলা একটা কিছু হইব। আচ্ছা বাদ দাও, এই
শাড়ি? শাড়ি কেন?
আমি কি তোরে কিছু দিতে পারি না?
এমনি করে টাকা খরচ করলে টাকা জমাইবা কেমনে?
দূর, একটা শাড়ির আর কতই দাম।
শাড়িটা কিন্তু সুন্দর আছে।
পছন্দ হয়েছে তো? আচ্ছা একটু পরে দেখা না।
আরেকদিন পরবো।
কি কস, পর না, তোরা অনেকদিন শাড়িতে দেখি না।
শরীরটা ভালো লাগতেছে না।
বেশি খারাপ লাগতেছে?
আরেকদিন পরে দেখা।
আচ্ছা ঠিক আছে, তাহলে খাবার দে। ও কি খাইছে? কি রে বাপ, আরে কি মশা রে।
Was on Tond at the time.
Yes.
Go
and
ahead.
He has bonds in all of those files. He would have to post himself.
Motion for bond reduction denied. Bond. Court calls case People versus Cottrell Roberson.
Good morning, Your Honor. Sydney rushing on behalf of Mr. Roberson, who appears to my right. Will you please state your name for the record?
Carter Roberson, sir.
I have before me a plea form. Is that what we're doing?
Yes, Judge.
Plea form indicates that the defendant will be pleading no contest to the charge of attempted possession of a loaded firearm in a vehicle, the 1-year offense. Upon a successful plea to that, count 3, counts 1 and 2 would be dismissed. There's a sentencing agreement to no upfront jail. I cannot bind the sentencing judge to that, but also there's an agreement no delayed or deferred. That supports full understanding of the agreement.
That's correct, Your Honor.
Yes, Judge.
Yeah, I haven't sworn.
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
State your name.
Carter Roberson.
Sir, it is this court's understanding that you're going to plead no contest to an added count 3. Is that your understanding?
Yes, sir.
That is the charge of attempted possession of a loaded firearm in a motor vehicle.
Yes, sir.
Indicated that's a misdemeanor punishable by up to 1 year incarceration, a $1,250 fine plus court costs and mandatory forfeiture of the firearm or device. Do you understand that?
Yes, sir.
Do you understand what a no contest plea is?
Yes, sir.
All right. 2 things about a no contest plea I have to make sure that you understand. First of all, I need to make sure that you understand that it means that you're not further desirous or wanting to contest this charge. You understand that?
Yes, sir.
Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes, sir.
You understand also, sir, that while I'm taking the plea, I would not be your sentencing judge and you would be sentenced before Judge Washington in the 14B District Court.
Yes, sir.
Basis for the no contest plea.
Civil liability, Your Honor.
So, sir, to that charge, how do you plead?
No contest.
Now, you understand that by pleading no contest, you'll not have a trial of any kind.
Yes, sir.
You signed an advice of rights form today?
Yes.
Any question regarding any of those rights?
No, sir.
Look at paragraph 5. You'll see a copy on the podium. Those are your rights that you're part of a trial. You understand that by pleading no contest, you'll be giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
Going to be reinstated for probation.
Pardon?
Probation, sir.
You're on probation? Okay, the court does have to advise you that your entry of a plea in this case could be considered a violation of that probation. If it is, that court could sentence you to the maximum allowable under that other charge. You understand that?
Yes, sir.
And you still wish to plead no contest?
Yes, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead no contest?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily of your own free will. And I want to ask that last one. Court has been handed and has reviewed Washington County Sheriff's Office report for their case number 24-41314. Any objection to the court having reviewed that report?
No objection, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant guilty of this offense. Counsel, have I complied with the court?
Yes, Your Honor.
Court will accept the defendant's no contest plea to count 3. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing in this matter will be August 8, 2024, 10 a.m. before Judge Washington.
Thank you so much, Your Honor. Your Honor, may I briefly address bond?
Yes.
Mr. Roberson's bond is currently set at 10%. He is unable to post that bond. Now that he has a conviction in this matter and we do have a sentence agreement to no upfront jail time, I'm asking Your Honor to consider lowering that to a personal bond.
He's on probation at the time this offense was.
Your Honor, they are aware of it, that he had the 2 hearings and his bond in those matters were lowered to personal bonds as well, while the pendency of this case happened. So this is the only case holding him in.
I understand, but at the time of this offense, he was on probation.
Yes, Your Honor.
Anything else?
No, Your Honor, other than, he does need to get out to help his family. He did have a employment as well that has been held, but they're not going to hold it much longer. So, Your Honor, I am considering or asking that you consider that he's already been incarcerated for 30 days. It has been lowered to a misdemeanor, and there is a sentence agreement to no more upfront jail time.
Any response from the people? I think because he was on bond, he's gonna have to post something. I'll lower his bond, but it'd be 10%.
Thank you so much, Your Honor.
Yeah.
We appreciate that.
If he doesn't show, we're gonna take you, Ms. Risher.
Please don't.
Just saying, that's how it works these days.